Good afternoon, everybody. Thanks for joining us. My name is Eric Hauge, and I'm the Executive Director at Homeline, and you're joining us on Wednesday, September 15th at 1:30 for another one of our Eviction Moratorium phase-out webinars. And today we're going to be covering the entire phase-out law and issues related to that, but focusing in a little bit on the recent change in phase that happened on Sunday, September 12th. We're also joined by Homeline's Managing Attorney and Hotline Director, Mike Vraw, and our COVID-19 Eviction Response Coordinator and Housing Attorney, Rachel Sterling. And we'll set aside plenty of time for Q&A as well at the end. Just a few introductory slides and some logistics. Homeline, we're a nonprofit organization that provides free legal advice throughout the state, and we've advised over 270,000 households since opening. And we have language lines in English, Spanish, Somali, and Hmong languages, and folks can call or email our hotline. Information is there about our free and confidential tenant hotline. Again, we will be covering general legal information and updates about tenant landlord law in Minnesota and the eviction moratorium phase out. If you have a specific question and you're a renter in Minnesota about your situation, please do contact our tenant hotline. We have a number of resources on our website that I'll put links to in the chat, but you may be aware of our phase out and timeline page, phase out timeline page and FAQ. And then we also have the schedule of upcoming seminars, which I'll share a little bit about in a minute, as well as previous recordings of seminars. And yeah, you're joining us today on the 15th of September. We have a full month of Wednesday afternoon webinars set up. All are free and public, open to the public. We'll just be doing another general overview next Wednesday. The following Wednesday, on the 29th of September, we'll be joined by Fourth Judicial District Housing Court referee Melissa Hotelling, and to discuss a little bit about what's going on in Hennepin County, how their housing court is processing eviction filings and hearings, and just some updates on that from her. And then the following week, on the 6th of October, we'll be joined by Dan Hilton, who I believe is the research director at Housing Link. We had both the referee on and Dan from Housing Link last year, and so this will be kind of a circle back with them. But Dan will be covering some housing, rental housing market trends that they've been seeing over the past year and a half, and as we move into the remainder of the phase out here. And then approximately a month from now, on the 13th of October, that'll be just a day after the next change in the phase out law, the big change on October 12th. So we'll be covering the details of that both on the 6th and the 13th. And before we hand things over for an overview of the phase out law to Mike and Rachel, just a reminder of the rental assistance programs that are available and that are specifically called out in the eviction moratorium phase out law as the programs that can protect tenants if they have a pending application. Rent Help MN is the first one, and the Zero Balance Project. Rent Help MN, of course, is statewide. The Zero Balance Project is focused in Dakota, Hennepin, and Ramsey County, and is landlord initiated. The application process is landlord initiated. And then also there's a separate kind of portal that you can go to if you're a renter in Ramsey County, St. Paul, and the rest of Ramsey County, that is under the same funding mechanisms as the others, but there's sort of a separate process, and our understanding is it can sometimes be faster for renters that are in those communities. I'll put information about this in the chat too. But with that, we will, in just a minute, I'm going to hand it over to Managing Attorney and Hotline Director Mike Vraw. Just a reminder that we do encourage folks to send in your questions. We prefer if you send them via the Q&A system on Zoom rather than the chat, so we can keep track of them. We did get a handful of questions in advance from registrants, so we'll hit those first after Mike goes through the overview, but we're welcoming your questions at any point, and we'll have plenty of time to tackle those at the end of the session. So with that, I'll hand it over to Mike.
Thanks, Eric. And I am very much so looking forward to the question and answer session. It's I looked at the questions we had submitted earlier, and they are a lot more varied than they have been in months. So that's always interesting to me to see what people are trying to figure out. But yes, please do submit questions. We have about 7 or 8 questions already lined up in the queue, but I know we'll have plenty of time. Probably the last hour or so of the time that we spend together will be devoted to answering your questions. So please submit them. Okay, let's do the overview of where we are, which we've been doing since April of last year, and we continue to do so until it's no longer necessary. The question we've been trying to answer since we began doing these pandemic-related webinars is, when can Minnesota landlords file evictions again, specifically for non-payment of rent? Because that is what Minnesota evictions are for non-payment of rent. Historically, roughly 90% of evictions in Minnesota are for non-payment of rent. And so that's been the key question all along. When can landlords file evictions for non-payment of rent? We had in place a set of peacetime emergency orders. There were 3 different versions that essentially stopped many evictions, most evictions, frankly, from being filed. That peacetime emergency, as most of you know, ended at the end of June of this year, and was replaced by a off-ramp / phase-out law. Session law is what it's officially called. It's not a statute. But this was passed by the Minnesota legislature, signed by the governor. And this is the law that we are all under, going through this phase-out period. So why don't we go ahead and go to the next screen and talk about the phases that we're in here. Yeah. Okay, so here's what's happening with the phase out. I've said this way before, but I think it's the easiest way to sort of grasp what's happening here. Landlords are reaccumulating their rights. That's really the easiest way to sort of mentally frame this. Landlords aren't getting any specific rights that they didn't have before the pandemic. They're getting the ones that they already had before the pandemic occurred, sort of reinstated to their toolbox, basically. And so, actually, can you shade us to where we should be now, Eric? Okay. Oh, one too far. There we go. Thanks. So what I mean when I say they're reaccumulating rights is the landlords got some new rights on June 30th, for instance. But when we go to the next phase, July 14th, they don't lose the ones they gained on June 30th. They just keep reaccumulating for the landlord. So every right that a landlord had on June 30th, they still have on July 14th. They still have on August 13th. They still have on September 12th. They keep those same rights that they'd already gotten back, but then new ones are added as we enter new phases. And so it's worth talking about the most recent phase that we just entered, which happened on Sunday, and then talk about what's going to happen in a month on October 12th, a big phase as well. So the September 12th phase, what we're calling phase 4, that's not an official name for it, but that's just the easiest way for us to kind of keep it categorized for us, is an important phase, no question about it. Let's look at what it does. It says that the landlord can now file an eviction for a tenant who's behind or who is ineligible for COVID-19 and behind on rent. They're ineligible for the emergency rental assistance. So that seems really similar to what we saw on August 13th, which, again, those of you that have watched a few of these shows know that we thought that that was among the least important of the phases, the August 13th phase, phase 3. The reason why is what a landlord is allowed to do because of that phase. So on August 13th, the landlord had the power to terminate a lease or not renew a lease if a tenant was behind on rent and ineligible for COVID-19 assistance. That's different than a landlord can file an eviction, the right that the landlord got on September 12th, just a couple of days ago. Now a landlord can actually go file the court case, pay their $300, start the case. It's an eviction technically. People also refer to these as UDs or unlawful detainers because that's what they were called for well over 100 years. And officially they're called evictions now, but we still in the trade refer to them as UDs. A landlord can file one of those cases now if a tenant is ineligible for the COVID-19 emergency rental assistance and behind on rent. So that is a big reaccumulation of a tool for the landlords, unquestionably. Now, how big is it going to be? How big is that going to impact the court system? It's a little bit too early for us to tell. We get information on a weekly basis on Sunday nights. So we'll have a much better sense of what the impact of phase 4 is when we do this speech again next Wednesday. And so we'll have a much clearer update. But this is an important additional right that landlords have reaccumulated, certainly much more important than the August 13th phase. And so we'll see how this plays out, how many evictions get filed from landlords that have been waiting for the money, realize that the tenant is ineligible, and then they go finally file the eviction that they've been waiting maybe over a year to file, is the truth about some of the cases that we'll be seeing. So phase 5, as mentioned, we're going to talk about that a little bit because it's another very important phase of the 6. What does phase 5 give landlords that they'll have suddenly in October, on October 12th? The big thing is that the landlords can start giving notices to vacate. They can non-renew leases. So somebody that was month to month, a month-to-month renter, has in fact had sort of good cause, as they call it, protection for, well, since the pandemic, peacetime emergencies really began in late March of last year. So a landlord couldn't non-renew somebody because they wanted to sell the property or something like that. Now, on October 12th, the landlord will be able to do that. We've talked about this a little bit, about how the timing is a little bit strange for landlords to suddenly want to give a notice to vacate at that time, or a non-renewal. Because the basic rule is, again, going pre-pandemic, if a lease is over, the basic rule is the landlord and the tenant can both say, you know what, our lease is over. I don't want to do another lease. So if the tenant is month to month, the landlord would simply have to give a month's notice, or maybe 2 months notice, depending on how the lease was designed. If it's a 1-year deal, which many leases are, then at the end of that 1 year, either side can decide whether they want to do another year or not. And the general rule is landlords don't need a reason to non-renew a lease. There are some exceptions to that, but that's the general rule. But that hasn't been the general rule during the pandemic. Landlords have not been allowed to non-renew a tenant or give a notice to vacate or a notice to quit, however you wanted to frame that. But they will be able to on October 12th. So will it make sense for landlords to give a notice to vacate on October 12th with a tenant that they've been frustrated with? That's, let's say the tenant's current on rent, but the landlord's just tired of dealing with this tenant. The problem from a landlord's perspective there is money. So let's say the landlord does give a notice to vacate on October 12th to the tenant. They've been waiting for over a year to do this, and they finally can do it. So they give this notice to vacate effective for the end of November or for the end of December, depending on how the lease is drafted. So what the landlord gets at that point is, on either December 1st or January 1st, they get an empty place. They can re-rent it to somebody else. The problem with that is the calendar. Is the landlord going to be able to re-rent at that time of year? Nobody wants to move on January 1st. I mean, if you get to pick one of the days of the first days of any month to move into a place in Minnesota, is January 1st going to be the top of your list? No, of course not. Maybe February 1st is worse. I'm not sure, but it's a close competition there. So I think there's a likelihood that a lot of landlords are going to do a realistic sort of business analysis and say, I don't want the tenant here anymore, but I should wait till it's warmer weather. It'll be easier for them to find a place. It'll be easier for me to find a replacement tenant. So maybe I'll shoot for the end of March. But there are going to be landlords that are going to give notices on October 12th. The midnight 01, they're going to be sending notices. We're fairly certain of that, having talked to tenants throughout the year and some landlords in speeches like this, that's what we're convinced is going to be happening on some level on October 12th. But again, we've just entered phase 4. We'll see what the effect is on the eviction amounts, how many evictions are being filed by landlords. This time next week, we'll have a much better sense of how big this new phase wave will be, if there is going to be a wave. Maybe landlords are still going to be holding out, but if the tenant is ineligible for the assistance, they're going to know that the money's not coming. So if they've been waiting to file the eviction, Sunday, 2 days ago or 3 days ago was the big day that landlords were waiting for. All right, let's go ahead and talk about a couple other aspects of the phase out. Go ahead and go to the next screen, Eric, if you could. All right, so this is the rule that we have in place for a little under a month, which is that if a landlord wants to file an eviction for non-payment of rent, they are required to give a 15-day warning notice first. It's got to be in writing. And so if a landlord has been waiting for that September 12th phase 4 moment to happen to file an eviction, but they didn't give a 15-day notice already, they'll need to give a 15-day notice now. They don't have the right to go to court today to file an eviction for non-payment of rent without giving the 15-day notice. Now, that's a very unusual rule in Minnesota. That's not what we used to have pre-pandemic. It is the rule in most states, something like that, maybe not 15 days, but some amount of time, a pre-filing eviction requirement. And I will mention that there are a couple cities in Minnesota that during the pandemic have enacted rules requiring pre-filing evictions. So Minneapolis and St. Louis Park both have a new rule in place that we've never really seen the impact of it because we've had the pandemic protection against evictions in place. So we'll see how that all plays out together. But up through October 12th, the landlord cannot file an eviction for non-payment of rent without first giving the 15-day written notice. It needs to say how much the rent is that's due and some information about where to get the rental assistance. And also a pretty basic statement that, you know what, I'm the landlord, I have the right to file an eviction now because the rules have changed, basically. A lot of tenants have been either not following it or following pieces of the information that's out there. There is a flood of information about evictions and what's legal and what's not. And some of it applies to Minnesota, a lot of it doesn't. And so people are confused about what the rules are. Again, one of the key reasons why we've been doing these presentations as long as we've been doing them is because we're not only trying to inform people, but we're trying to fix the misinformation that's out there everywhere. Not specifically somebody trying to misinform Minnesota landlords or tenants. It's just that if you hear something on CNN or Fox News and you think it might apply to Minnesota, probably it hasn't really applied much to Minnesota. And so the filters that we might all have in place telling us what information online is credible for our situation might not be that accurate when it comes to the situation. So that's why we do the webinars that we've been doing. Anyhow, the 15-day notice for non-payment of rent, still part of the off-ramp phase-out rules that we're playing by, and that's going to matter until October 12th. All right, let's go on to the next point. So we didn't talk about this, which did show up in the chart as well, but there is one last phase that will happen after October 12th of this year. We don't have any more phase changes until June 1 of next year. That's right, 2022. That's not a mistyped phrase there. So this safe harbor provision protects tenants that have a pending application with Rent Help Minnesota, which is the biggest program that is doing this, or some other emergency rental assistance program. They're specifically noted which ones count in the session law. But a landlord can't file an eviction or proceed with an eviction for non-payment of rent. Again, it's all about non-payment of rent. We're not talking about if you have a dog and you're not supposed to, if you have somebody living there and you're not supposed to. Material breaches is what those are. Landlords can already file evictions for those. They've reaccumulated that right. And that's not going to be taken away again under the phase-out rule that we have. But for non-payment of rent, which is once again almost every eviction in Minnesota, the landlord can't file an eviction for non-payment of rent or continue with the case, basically, if the tenant has a pending application for rental assistance. And so that protection is in place. This was put in place, at the end of June when Rent Help was really struggling to get the money out the door. It's gotten somewhat better since then, but it still takes time. The application process still takes time. And I think the theory behind this, again, this was agreed to by the Senate, which is controlled by Republicans, the House controlled by Democrats, and the Democrat governor, Governor Walz. The reason why everybody agreed to this is because, well, in the end, it's probably best for all the interested parties. Landlords want to get paid. That's what they really want. And so we want to pay landlords, get them made whole for all the money that they didn't get over time. We've got this giant safety deposit box full of money that Minnesota has from the federal government that's waiting to be dispersed to landlords to make tenants whole and landlords whole as well. And we'd like tenants to be able to have stable homes after this as well. So the theory behind all this money coming is that there's a lot of people that didn't lose their jobs because of anything they'd done wrong. The world just fell apart because of a pandemic. And so we wanted to make sure that they were able to remain housed. We didn't want people moving about. That would have increased the rates of transmission of the virus. We also didn't want tenants to be unfairly punished for losing their job in a system that they didn't do anything. They didn't show up drunk to work or fail to show up to work. Work just stopped. It just stopped for a lot of people. And that's restarted for a lot of folks. That's one of the reasons why the eviction moratorium is gone. But we want to get landlords paid is what we want. And then tenants will be also getting a pretty big benefit from that as well. So that's the theory behind this. Hey, you know what? If there's a pending application, let's just pause the entire court process or not even let it start until we figure out what happens with the application. And it's somewhat remarkable that it went through June 1 of 2022, but that's the law that we have. Okay, now we're going to do a couple new topics here that we've never talked about, at least not in depth. We've mentioned this stuff, but we're going to try to dive in a little bit more. The first is because this plays a much larger role now, and it will continue to play a big role through next June. So what is a pending application? Minnesota Housing, which is in charge of the rent help program, prepared a guide that was published last week, I guess it was. And so that's where I'm taking this information from to try to get the most current and explicitly spelled out versions of what these things mean, a pending application and some income eligibility, which I'll talk about in a second. So a pending application is one, this is the quote, has been submitted and has not been denied, withdrawn, or paid. Okay, that's our pending application. If it's not complete, so if the tenant hasn't submitted all the proper paperwork that they're supposed to, that's not the same as pending. If payment is deemed ineligible, then the status will be updated in the system and the tenant will be sent a written denial notice. The tenant can appeal that. And during the appeals process, the application is considered pending. Again, the theory behind all of this stuff is to try to get landlords paid eventually. That's the goal that I think everybody has in mind. But that is the sort of the black letter official version of what a pending application means in the systems that we're talking about here. And the guidance that Minnesota Housing put together clearly is relying on the language that was in the session law, which was relying on some of the language from the funding that we already had in place. So they're mirroring languages, which is nice. So we have a decent idea what a pending application is. And they clearly wanted to define this in their latest guidance to make sure that everybody understood what a pending application in their mind was. And on to income eligibility. So this is another way to determine who's eligible for some of this money. It's up to 80% of something called the area median income. AMI is the shorthand for that. And so there are several counties in the state that are the highest AMI. They're listed in front of you. They're sort of metro-ish with a couple outliers as well. But we just put on here for a family of 4, it's up to about $80,000 is who is eligible for this money. The lowest one, which you'll find in less densely populated counties, is a little bit under 60,000 for a family of 4. And there are a lot of levels in between there. So not every county is going to be at the 59,600 for a family of 4, but many are. So there's 87 counties in Minnesota, and there's I don't know, there's probably 10 different income levels that I think might exist. I didn't count them up, but there's a lot of different ones that are out there. But we see the lowest and the highest on the screen. And so that's the income eligibility portion of the emergency rental assistance analysis that one would do. Okay, let's talk briefly about the federal stuff as well. I mentioned earlier that people might get their news from CNN or Fox News or Facebook or Twitter or wherever. And most of that's going to be federally based, federally specific or federal specific, which you might think applies to Minnesota as well. And in some cases it does. So the CARES Act is the first thing I'm going to talk about, and you have to go in the Wayback Machine quite a bit here. This was the first major piece of legislation that the federal government passed trying to cope with COVID-19, very bipartisan, I want to say April of last year. And it had a lot of provisions to it, including the first parts of the stimulus packages that we're all pretty familiar with to this point. It also included some information about housing and some rules and regulations about housing. It banned non-payment evictions through July 25th of last year. So that's not a typo. Once again, 2020, July 25th, 2020. So why are we talking about it now? Well, that had a notice requirement built into it, the CARES Act did. And this notice requirement never sunsetted. So what do I mean by notice requirement? Well, similar to the Minnesota notice requirement that we have, the 15-day notice requirement, the CARES Act had built into it a 30-day notice requirement that landlords had to give once the July 25th date had passed if a tenant owed rent. If a landlord wanted to file an eviction for non-payment of rent in a CARES Act covered building, which I'll talk about who that is in a second, then they'd have to give a 30-day notice first. That law never sunsetted, as lawyers or legislators might say. It's still part of the law of the land. And so, yeah, a landlord in a CARES Act covered building almost certainly needs to give a 30-day notice. We haven't really seen that fought about much in Minnesota yet because we just haven't really had the non-payment cases so far. But like I said, they'll really be starting officially 2 days ago is when they really began, or 3 days ago, I should say. So who's a CARES Act covered building, or which one is a CARES Act covered building? Well, pretty much any place that has a federal subsidy of some type is likely to be covered by the CARES Act. The broadest definition that the CARES Act actually uses is any place covered by VAWA, the Violence Against Women Act, is also covered as a CARES Act covered building. It's not just those, though. It could be something like a fourplex where you've got a mortgage that's federally backed by a place like Fannie Mae or Freddie Mac. So the CARES Act, as evictions start to return, we go back to the pre-pandemic levels. Unless and until this gets repealed or ended, a landlord filing a non-payment of rent case in Minnesota would have to give a CARES Act notice if they're a CARES Act covered landlord. So this is a new sort of, I guess, threshold issue, as lawyers call them, that a court should be considering when there's a non-payment of rent case. And so we'll see how that plays out going forward throughout the court system. Last up is the CDC moratorium. I want to talk about that for just a second because it's the one that most people have heard the most about. This is a federal moratorium that was in place. It was enacted during President Trump's tenure, actually September of last year, where it was instituted, banning non-payment of rent evictions throughout the United States, basically. And that was a huge impact on the landlord-tenant community. Almost immediately, there were lawsuits that were filed. Several, I think at least a dozen lawsuits around the country that culminated finally in the US Supreme Court striking it down, at least the most modern version of it, the most recent version of the CDC moratorium, striking it down late last month. Actually, we had given a presentation the day prior to the announcement of the order. And I looked back at the last version of our program that we'd put together, and I'd written down on the slides, chances of being overturned pretty high. It didn't take a real soothsayer to figure out that moratorium order was in danger. There'd been an earlier order where Justice Kavanaugh specifically had written that they were going to allow the CDC order to go on because it was going to be ending anyway very soon. But unless Congress had ordered something like this, that Justice Kavanaugh basically was saying, I ain't going to vote this way again. And true to his word, he did not vote that way again. And so the CDC eviction moratorium ended officially August 26th around the country. It's always had a pretty limited impact in Minnesota, the CDC order. because we had stronger state protections. The CDC eviction moratorium always explicitly deferred to any stronger local protections, whether it was a state law or a county law or even a city law, which we saw in many places around the country. And so that is the end of the CDC moratorium. Could Congress pass something like that? Sure. I don't think it's something that doesn't require a filibuster, though. So that means you'd have to get 60 votes in the Senate, which seems very unlikely. So I think it's very unlikely we're going to see a federal ban on the evictions unless, but who knows, if the pandemic decides to create a new variant and you know, the hospitalizations and the vaccination doesn't work at all or whatever. I mean, it's not hard to imagine things getting worse again, prompting legislators both at the state and federal level to feel like they need to take action. But that's what we have. The CDC moratorium is now gone, it's done. So we're left with what we have from the state, and the CARES Act notice requirement are pretty much the remaining puzzle pieces that we need to figure out when landlords can start to file non-payment of rent evictions again. Okay, that is 30 minutes of Mike talking nonstop. So I'm gonna pause for a second and have a drink, and then we'll get to some questions.
Thank you, Mike, for taking us through that somewhat of a maze, but it's less of a maze now that we've gone through it. Again, we ask you to submit your questions. We had maybe 7 or 8 sent in advance, which we'll get to, and we see 9 have come in the Q&A. If you can, please keep your questions to the Q&A system rather than the chat. It's just easier to track them if at all possible. Appreciate that. And so what we're going to do here is I'm gonna ask some of these questions, and Mike and Rachel are maybe going to trade off or buzz in first with their answer.
I was not provided a buzzer.
Oh, isn't that just a Zoom functionality thing we have to turn on?
I can probably find a buzzer.
I think we'll just alternate, but I'll let her go first since I'm, you know, still recovering from my 30 minutes of nonstopness.
All right. All right, so here we go. We're again starting with questions that we got in advance, but we have plenty of time here, almost a full hour. So the first one's from Tim, and he asks, can eviction actions be filed prior to the October 12th phase out date for a hearing on or after that date?
So Tim, basically what Mike just going over was the reasons at this point why someone could file an eviction. For as long as it meets one of those exceptions, then the phase out allows for an eviction to be filed for those particular reasons. If there isn't one of those particular reasons laid out specifically in the phase out, then it's not allowed until after October 12th.
All right. An anonymous submission from a tenant. Can a landlord file anything like a non-renewal eviction if my lease expired May of 2021 and the landlord has accepted rent money through November?
So this is the problem with taking questions like this, is you can't ask clarifying questions. And sometimes it's hard to really figure out what somebody's trying to figure out. So can the landlord file something like a non-renewal eviction if my lease expired May 2021 and has accepted rent money through November? So I think the tenant's maybe, I think this question's from a tenant. I think the tenant is maybe asking about something we call a waiver. I'm not exactly sure. That's my best guess. So a landlord doesn't really file a non-renewal eviction. They file an eviction for holding over is what it's called. How that works is if I'm the landlord and Rachel's my tenant and it's a month-to-month lease and I give her a notice to vacate, there's no pandemic rules. I give her a notice to vacate for the end of October. On October 31, she's supposed to leave. And if she doesn't, then on November 1st, I go file an eviction for what's termed holding over. So it's not a non-renewal eviction per se, but I think that's what that phrase means from the tenant's question. The fact that her lease expired earlier this year, and we've been going month to month since then, probably transforms the lease into a month to month lease is what it does. And that doesn't mean that she's got protection forever. Now, this question says that the landlord has accepted rent money through November. I think that is really problematic for a landlord trying to give a notice right now. Let's say there were no pandemic rules. Can the landlord give a notice if they've already accepted rent for that month in advance? We don't traditionally see that a lot, future rent payments happening. It used to be pretty rare. I think we're going to see a lot of it for the next year, where tenants might have qualified for help from rent help and maybe gotten a couple months paid in advance as well, which is a tricky question for the landlord trying to dodge a waiver type defense. If they accept that prepaid rent for the next couple of months, can they evict during that time? And we're going to see this play out, I suppose, over time. But I think that's what the question's asking me. I'm not exactly sure. If somebody were calling our tenant hotline, which Eric has put on the screen, we'd be asking a lot of follow-up questions. Or if this was an email sent, we'd be asking the same number of questions.
All right. Next is from a landlord named Eric. This question is, are courts actually finding in favor of landlords for any legitimate lease violations? I've heard this is rarely happening now.
So I can't say for certain what every case is being held for or against landlords. We are trying to track evictions that are being filed, but we don't necessarily track all of the outcomes. It's a very big job to do. So I can't really say for certain that, this rumor is true or not true. But what I can say is that what I've seen is that, yes, landlords are successfully getting writs of recovery is what the court would be granting to a landlord for numerous eviction filing reasons, so including lease violations. I think sometimes where I've seen some holdups, if I have managed to catch a lease violation hearing, is the court is asking the landlord to show where the tenant was informed that such actions would be a lease violation. So some of those lease violations are part of the statute, like the illegal activity action would be technically a lease violation, but it's inherently part of any lease because of how it is worded in state statute. But other lease violations, a tenant needs to be told that it's a lease violation, or would be a lease violation if they did that act. And so that can be sometimes, I think, a trickier thing to prove, especially if at this point it's the action, if the tenant didn't know that it was going to be a problem, or maybe it's the court is questioning whether it's a material violation. Because I think one of the things to question is whether does it actually get to the heart of a lease? The fact that someone is smoking in their unit, is that really making the lease just not enforceable anymore? Mike, you have a lot more experience just historically in this realm of eviction reason. So if you've got anything to add to that.
Well, yeah, I mean, landlords are winning cases, right? I mean, that's
Yeah.
kind of what the question was asking. Are landlords winning cases for material breaches now? And there's no question that they are. Do they win all of them? No. Nope. They got to prove it up. I'm still suspicious of any landlord filing a case for a material breach and they list non-payment of rent as well, which, doesn't really help their case right now, in my mind. I think that it gives a sign of what they're really caring about, which is the same thing landlords have historically cared about, which is, has the tenant paid the rent? But yeah, landlords are definitely winning material breach cases. Yeah.
All right, another question from a landlord. Kay asks, does my tenant need to have applied for rental assistance before I can evict him for non-payment of rent. And then it got cut off, but they were saying, who would we call for? Maybe to find out about that.
Yeah, can you scroll to the next slide, Eric? It's got the chart on it again. We'll just use that to talk about this. Thank you. So yeah, we look at our chart again, and again, we're in phase 4, which is what we just entered. So the September 12th is the most recent change. And the question is, does my tenant need to have applied for rental assistance before I convict him for non-payment of rent? So we know that landlords can now evict for non-payment of rent as of September 12th if the tenant is ineligible for the rental assistance. So, I mean, I guess a tenant could sort of look at the requirements and say, oh, I'm not eligible, and not apply and realize that they're ineligible. But if we look back at some of the earlier phases, the landlord could file evictions for a tenant who owed rent and refused to apply or cooperate with or provide landlord with proof that they'd applied. And as we mentioned earlier, the rights accumulate. It's not like you don't get your June 30th rights anymore because we're onto a new phase. You still have those rights in place. So the landlord would argue that the tenant isn't cooperating or hasn't applied or hasn't given me any evidence that they've applied. The question that a landlord has to try to figure out is, do they think the tenant's going to be eligible? I guess because the tenant could at any moment apply, right? Even after the eviction is filed, the tenant could go apply for the rent help assistance, and they would be protected. It would stop the case from proceeding up through June of next year. If I'm a landlord, I'm going to want to communicate with the tenant. I mean, that's one of the reasons why the 15-day notice is so critical. Hey, I can file the eviction right now in 15 days. Here's how much you owe, and you should try to get this help. There are going to be tenants that are out there that don't know that that's true. They don't know that that's something that's actually maybe available to them. Maybe they've never received any kind of public assistance in their life, and they didn't really think it applies to them. Trust me that we talk to people on the phone that say things like that all the time. I had no idea that why is somebody going to pay my rent? That doesn't make any sense to me. And so there's this disbelief that you might have to get past. So a landlord might be able to successfully file an eviction. Again, you have to give that 15-day notice first of the non-payment of rent and how much is due. And hopefully the tenant will go apply and find out if they're eligible or not, because it's better for everybody if you get paid as the landlord versus simply regaining possession of the place, which is all the eviction really gets you.
Right, thank you, Mike. The next one is from a resident of a manufactured home park. And I don't know if we can answer this one, but the general question is, my ask is, why is it taking so long for Rent Help MN to pay? This is actually a member of a cooperative manufactured home park. And so they're saying the co-op of the park has bills to pay.
That is a complaint, I think, across the board, is that why is it taking so long? We don't have our fingers on the pulse necessarily of the Rent Help MN program, since we're not a field partner, and it's not being administered in any way, shape, or form through our organization. But yeah, at this point, everyone is frustrated. Landlords, tenants, field partners, everyone is frustrated at how long it is taking. They're slowly getting money out though. So as frustrating as it is, patience is the byword for what we're hearing from them.
I'm going to put it in the chat. There was a commentary in the Star Tribune today about the slow speed at which rental assistance is getting out, just to share that. Moving to the next question. Joseph, a landlord, asked, can you still end a tenant's lease when it expires and not renew it in Hennepin County?
Mike, you're on mute.
Sorry, thanks. First time on a Zoom call. Yeah, I got that question. I think what they're asking about is they've heard about just cause protection, maybe in the news, maybe they've read about that or something like that. Or maybe they're just concerned about the pandemic part of things. So can a landlord, first of all, there's no Hennepin County rule about this. There's no specific Hennepin County rule on when a landlord can give a notice to vacate. Nothing that I've ever heard of. If you're going to see a rule like that, it's either going to be a state law or it's going to be a city law that would be regulating that. So there's nothing specific to Hennepin County. But yeah, I mean, the short rule is that once we're past October 12th of this year, a landlord can decide not to renew a lease. That's the general rule for landlords. Now, you can't discriminate against tenants. You can't decide that, oh, you know what, I'm going to not renew everybody's lease if they happen to be Catholic, because, you know, that's not the religion I'm into. So I'm going to get all the Catholics out. You can't do it for a religious reason, for racial reasons, for all the protected class reasons that we've all heard about for years. You can't retaliate against a tenant for asserting their rights, like calling a city inspector. But yeah, if the lease is over, it's a contract that ended, and both sides get a chance to say, I don't want to renew the contract. And once October 12th rolls around, landlords will reaccumulate that right.
All right. Just a couple more questions that were submitted in advance, and then we'll get to the 16 in the queue here. Kimberly, a tenant, says, my landlord returned my security deposit postmarked well after the 21 days. I was told I could charge them a $500 penalty.
That's a non-pandemic related question. That's fun. So the circumstances could get a little specific. You might want to call into the hotline to discuss your specific circumstances and what options are available to you. But in general, there are some fairly straightforward rules when it comes to security deposits. And one of them is that a landlord needs to return either the deposit or a letter detailing why a deposit is not being returned. It has to be put in the mail basically within 21 days of the tenancy ending, and the tenant giving their forwarding information. And so again, I would urge you to give us a call on the hotline to discuss, to make sure that all of those factors have been met before we start talking about how you could potentially go after them if there's a $500 penalty or any other damages that may be entitled to.
And security, you mentioned that it's a non-pandemic question, Rachel. I should just mention that we still get a lot of those non-pandemic related questions. Security deposits are somewhat seasonal, the questions that we get about security deposits, because they happen when people move in and move out, right? So when transitions occur. I mentioned earlier that nobody wants to move in January or February in Minnesota. So we have kind of this 6-7 month window of time where people move in and move out in general in this state. Landlords want leases to end during these warm weather months. Tenants want to move during the warm weather months. It's better for everybody. So yeah, we've had a wealth of deposit cases this summer, I think more than last summer. Yeah, so we're absolutely dealing with these on a daily basis. Please don't think that you need a pandemic related question to give us a call.
Absolutely.
All right. Okay, the next question, the last submitted in advance question is from Kim, a different Kim. This is a landlord. Kim says, I have heard several rumors and want to know if true, if you file for eviction for serious damage and or material breach, and the tenant has a pending application for past due rent, can the landlord still collect the rent help MN funding for past rent? I have heard that if you evict for something other than non-payment of rent, it does not disqualify the funding.
Eric, I know you had some thoughts on this, if you wanted to start on it.
Sure. So let's see here. Tenant has a pending application for past due rent. Can we, and they evict for some other reason, it does not disqualify the funding. So there has been some Treasury guidance, and Mike, in his earlier comments during the presentation, talked about some of the changes that Minnesota Housing made to the Rent Help MN program guide. And we put a link to it in the chat. Some of those were in response to recent guidance from the Department of Treasury, U.S. Department of Treasury, who is sort of the boss of the money throughout the country and kind of provides direction to the program administrators in each state. And some of that guidance did talk about permission to allow payment of rental or utility arrears after the tenant is no longer there. It did talk about again, the U.S. Department of Treasury guidance talked about the need for a tenant to request the assistance and that there be some evidence of that. Our understanding is that Minnesota Housing has added a statement about this to their program guide, but we don't have any information beyond what's in the program guide about how that process works. Obviously, it seems like the tenant probably would not give authorization or request the assistance go to a landlord who had evicted them for some other reason.
Well, they might. I mean, they might want to settle up the debt just to have the debt eliminated from their history. So it's possible that the
Right.
tenant could request that. Yeah.
Yep. So not a ton of clarity on that right now, but there may be in the future. Again, it is in the Treasury guidance that was released a few weeks ago and then updated in Minnesota Housing's program guide, which I put a link to in the chat earlier. I don't know if there's more to comment on that.
Not really. No, I mean, it seems to be evolving. I don't think it's necessarily the same answer that would have been given 2 months ago, and it might not be the same answer in 2 months as well. So I don't know. It's just what we've been seeing.
Okay, let's see here. I think we've tackled everything that was submitted in advance, so we'll jump over to some that are in the Q&A. We got a question from Tim. How can a landlord verify eligibility or ineligibility for COVID-19 rental assistance if the tenant does not cooperate?
Sorry, excuse me. I was coughing up a storm just a couple seconds ago. So excuse me. So Mike went over a bunch of eligibility criteria set forth by the Rent Help MN program, or the program that the person is applying for, zero balance, the Ramsey County one, what have you. So using those, the burden is on the landlord. If you're going to say, I'm evicting you for non-payment of rent and you are ineligible for the Rent Help MN program, the burden is on the landlord to prove that they're ineligible. So how can they do that? The guidelines for eligibility are listed within the programs themselves. So you can figure out how to show that currently at the moment, the tenant is not eligible, then that is probably, the best way to be able to do that. If they're not cooperative, then that's frustrating, but as Mike was saying, honestly, being able to prove from one moment to the next whether a tenant is eligible or not is going to be difficult to do, honestly. With even if there's they have applied for Rent Help MN and have been told that they're ineligible, but they're appealing the process, or they've reapplied because from when they first applied back, say in April to today, their eligibility has changed, and so their circumstances have changed. So now they are eligible for the program. Like, it's all in flux. So I think that's going to be that is going to be a hurdle to overcome.
All right. We might have some repetitive type questions and topics, but we're just going to ask them all because we have the time, and it's good to reiterate some of these points. So, okay, next one is, excuse me, from an anonymous attendee. If the landlord does not want to renew the lease at the end of September, this tenant is on a month-to-month lease, and the tenant has not applied for rent help MN, can the landlord choose to not renew at this point, or is the tenant in this situation protected until October 12th?
Well, yeah, I think a tenant is protected from a non-renewal through October 12th. So the landlord has to wait until October 12th to be able to give the non-renewal. You can't give an anticipatory non-renewal now. You just have to wait until October 12th. That's just how the session law was drafted. So I'm not sure that it matters that the tenant has applied for rent help or not. I mean, the landlord is talking about just giving a non-renewal for no reason versus for non-payment of rent in the question here as well. But certainly no non-renewals for no reason at all until October 12th hits.
Can a landlord file an eviction after October 12th where the notice to terminate a lease ending prior to 10/12 was sent prior to 10/12, or would they have to terminate the lease before filing against the tenant?
This one sounds similar to what Mike was just answering. I will say that, if there is a valid lease termination reason that falls under one of the exceptions in one of the earlier phases prior to phase 5, then the lease termination would be valid, probably, and a lease, and then filing that eviction once it became available in one of the phases would be available before 10/12 happened.
All right. Okay. Lauren, who identifies as a landlord, has a question here. I was approved to receive the 15 months of rent back owed from the zero balance project. Is there a requirement to keep my tenant for a certain period of time after I receive those funds? Or can I legally give a notice to vacate after October 12th phase out date? No new lease was signed and the tenant was on month to month.
And Rachel, I don't think there's any requirement that the landlord let the tenant stick around after getting paid back rent, is there?
It's left up to the programs, and I'm not aware that zero balance has any of those requirements. I know that there's potentially discussion about having that when some of the phase 2 monies start coming in,
Sure.
which I know I'm banding around more phases. So I'm sorry that word comes up quite a bit, but there are different times of when funding comes in from different programs. So my understanding is that Treasury's guidance is just heavily suggested that programs have some sort of restrictions in place, but not familiar. I don't think the Zero Balance Project has one.
So again, this is something that I brought up earlier, but I think it's worth repeating again. If you're a landlord in this position and suddenly on October 12th, you have the power, you have the legal right to give a notice to vacate, does that make sense to do it though? It really is a calendar analysis. Do you really want to give a notice to vacate to a tenant for the end of November or the end of December? From a business perspective, you have to decide, is it likely that I'm going to be able to re-rent the place? I've been doing this a long time, and I can guarantee you there are more places available on July 1 than there are on January 1. Landlords don't advertise places then, tenants don't want to move then. So if you kick somebody out the end of November, the end of December, it might be sitting empty for 2-3 months. And even with the vacancy rate starting to go back in favor of landlords, doesn't mean you're going to get somebody moving in. And so I think a smart landlord is going to look at the bottom line first and think, well, do I want to chase them out right now because I'm not sure if I can re-rent? It's got to be part of the business analysis.
I also,
oh, go ahead.
Sorry, I also want to make sure to point out that if it's any forward rent, that does make some restrictions for kicking somebody out if you've already accepted the money for that timeline.
Right. The question was just back rent, I think.
Mm-hmm.
Yeah. But yeah, absolutely. Good point, Rich.
So I do know that the Treasury guidance strongly encourages that that there be provisions create that kind of condition that there's a protection for 30 to 9 or 90 days beyond. I don't, as you both mentioned, I'm not sure if that's part of Zero Balance. They just also updated their program guide. Minnesota Housing updated their program guide, like we mentioned, for Rent Help MN, and it does say in the program guide, landlords and property owners are prohibited from evicting a tenant for non-payment of rent for any period covered by rental assistance through the program.
So that was that forward rent that Rachel was just talking about,
Yep.
right?
Yep. All right. Okay. A question from Tim. I'm confused here. Is notice of the decision sent to the landlord? I guess notice of the decision about eligibility for Rent Help MN is the question, maybe, or denial.
Yeah, I'm not sure what shows up on the landlord's dashboard. Is that the right word for it? Dashboard? Do landlords use the dashboard too?
Yeah. My understanding and from what the program guide says is that when a change in application status is made, the whole system is updated to reflect that status. So a landlord's dashboard should reflect it. If this is a Rent Help MN question, I honestly have no idea about the other two programs that are.
I've also heard there's something of a lag sometimes between what's been decided and what shows up on dashboards as well. So
it's also sometimes, especially if a tenant and a landlord never get connected in the system, the landlord may never get the notice for that.
And when we had folks from Rent Help MN on 2 months ago, I'm not sure when it was, they did provide this as a contact point for landlords with questions or issues with Rent Help MN. I put it in the chat. Okay, moving on. Anonymous question. Can I give a 30-day notice without cause on September 30 for October 31st, or do I need to wait till October 12th for November 30th?
And I'll take it. I'm not sure who's up here next, but short answer is no, you can't give the 30-day notice without cause on September 30th. Not to put too fine a point on it, but it wouldn't be a 30-day notice. It'd be a full rental periods notice. You want to be careful whether you're a landlord or a tenant, making sure that you phrase this properly. In general, it has to be in writing. A notice like this does. It has to be properly timed as well. So you could give one on or before September 30th for the end of October. But the real question here is, do I need to wait till October 12th to give a notice for November 30th? And the short answer is you have to wait till October 12th, which is why I keep talking about how the calendar plays a big role in the decision-making. It's not just what does the session law allow me to do? What does this chart on the page allow me to do? Is what's best business-wise from a landlord's perspective. Does it make sense for me to actually chase somebody out for the end of November? Because maybe I can't get somebody for months.
And we kind of already answered this one, but we'll ask it again. Anonymous question. Can a landlord choose to not renew a lease? Can a landlord choose to not renew a lease after October 12th if someone has a pending application for Rent Help MN?
Short answer, yes. If the protections are for non-payment of rent related evictions at that point.
And as well, go ahead, Mike. Were you gonna?
Nope. No, I'm just waiting for the next question.
I was just gonna say, as has been discussed already, there's the business decision around will you be paid if from that pending application. Right now, probably not. There might be this guidance that will allow it, but it's dependent on the tenant's decision. Sounds like it will be. Another question from Timbaland. How long does it take from time of application by tenant for the landlord to get paid? I feel like we need to get somebody from Rent Help MN on here.
I think the answer is it varies. I think that's the only answer that they could give. So yeah, I think it varies a lot. They have to confirm things, and it probably matters on the amount of cases that are in front of them in the queue, that sort of thing. So I don't think I can give a general answer.
Yeah, and somebody I did notice in the chat, trying to find it. Oh, we had a message from a chat in the chat from somebody who I think maybe is service provider or maybe a rent help amend field partner who said I've assisted, or maybe a landlord, I'm not sure. I've assisted close to 100 applicants to submit their applications, and I still have applicants that say pending since their application went in May of 2021. Okay. Another one from Tim. Is staying beyond the expiration of a lease a material violation?
So holding over, essentially, I think we've talked about that. There are, one of the things I've said in the past is that if you are saying that the lease, if you're trying to argue that the lease has ended and that someone is holding over past the lease, then how can the lease that you're arguing is no longer valid also be violated? Would be one question, but but the basis of that is that holding over evictions just aren't listed as an option under the phase out until October 12th. Short answer for that too.
All right, I think we answered this question already. Carrie asks, a tenant that has material lease violations that qualify for eviction on 10/12/21, but also has applied for rent help amend, can the landlord evict for lease violations? You can evict for lease material violations of the lease right now. So I'm not sure.
Right. The question is, does it make sense to do so? Because I'm guessing what this landlord is hoping for is that they can evict and still collect the money, which is not a sure thing with the tenant maybe not cooperating with that. It seems like that's required for the tenant to cooperate with that application if that money's going to happen at all. So a landlord, could they do this? Yes. Is the tenant stopped, or is the landlord stopped from filing an eviction for material breach because the tenant has applied for rent help? No. They can still file an eviction for material breach. The question is, does that make sense? Or do you want to get paid the 10 months of back rent that you're hoping to get paid for? Which is the business analysis that a lot of landlords find themselves having to do.
Yeah, so long as the material breach isn't non-payment of rent, to clarify.
Okay, we had one in the chat that well, actually, why don't you all, I put it in the doc, why don't you all look at that quick? Go to the next one. Carrie asks, if we have a mutual lease termination that has resulted in a tenant holding over after the agreed upon date and has a material violation, what are our options?
I think, sorry, this one's mine. Basically the same answer that Mike just gave. If there's a material lease violation, then that is an allowable eviction reason under the current phase out, but you just got to make sure, you know best what makes sense for your situation. So.
Okay, anonymous question. How would a tenant be treated who has a lease which states month-to-month tenancy must be approved by landlord, and landlord sent them a lease termination with no reason before the October 12th phase? Would they automatically be a holdover, or would their lease be considered month-to-month if they have been paying?
Yeah, I'd want to talk to the person on the phone just to pin down some details here. But what I think has happened is that the tenant had a 1-year lease. It rolled over into a month-to-month lease, and the lease says that it's got to be approved by the landlord, which is language that is pretty common in leases. But when the landlord accepted the rent, once the lease rolled over into month-to-month, I'm guessing a judge is going to say, well, that's sort of the modification by the parties. Tenant offered, landlord accepted the rent, so we've got a new contract that's formed, this month-to-month contract, with all the original terms probably still intact. Best guess based on what we have here.
Okay, Rachel, you're up next. A question from Eric. All right, let's see. Never mind. That is not what we're looking at. Sorry, we'll move on to this one. Tim asks, how does a landlord find out That we already answered that one, I think.
Mhm.
Tenant ineligible. And what if the tenant refuses to communicate with the landlord in that situation? If landlord doesn't know if the tenant's ineligible, what is the tenant refuses to communicate with the landlord?
So one of the eviction options that's been available since June 30th, is if a tenant is refusing to cooperate with the landlord on the application process for rent help MN, that's an evictable uh, reason at this point. You know, if the landlord is trying to determine eligibility and the tenant refuses to communicate with them, that's certainly a struggle. And I honestly don't know how courts would view it one way or the other to decide if that's a reason or not to fine for the landlord or not in that situation. You know, this became these became an option on Monday. So I don't think anyone's heard these cases. You know, no one's actually heard these cases yet. So that is evolving.
Okay, we actually had two questions that came in about this. Does the eviction and this is to Mike, does the eviction moratorium prevent a lease from terminating under Minnesota Statute 504B 206 Subdivision 3B, which I will put in the chat?
Yeah, so that is the statute that allows a tenant to break a lease in the case of domestic abuse or a victim of violence. The subdivision reference specifically is one where there's more than one tenant in the property. So you have the abuse victim that is breaking the lease. This is one of the few ways a tenant can unilaterally break a lease without the landlord's agreeing to it. So we have, let's say it's a tenant or two tenants plus the landlord. So it's a three-party contract. And tenant one, who's the victim of abuse, uses this statute to end their lease early. And subdivision 3B allows, actually doesn't allow, it terminates the lease at that point, effectively, for roommate two, who might have had nothing to do with the abuse or maybe was the abuser themselves. And so I think the question is, does this sidestep the pandemic limitations on evictions? And I don't remember if that happened during any of the executive orders specifically. I believe it does under 171 if it's the abuser that is the remaining roommate, but if it's some innocent roommate and the abuser is somebody else, it's a tougher legal question. I'd recommend that you have whoever is sending in this question to get in touch with us directly, so we can talk through the details specifically about this. Because we don't, first of all, this isn't something that we are truly experts at. There are domestic abuse advocates out there that work in this statute on a daily basis. We do advise people on it, but it's not anything that's anywhere near the top 10 things that we talk about with tenants on a regular basis. So we're not the true experts on this. But I can say that we don't offer a lot of advice to people who've been accused of abusing people. They're just not the ones that tend to call our office. So I'm not sure I've been asked that specific question before. We try to piece it together. This would be one of those things where we'd probably have several of our attorneys talk about it and figure out whether we think that there's any footing as well. But sorry, it's not a better answer than that, but that's the best I can do, sort of talking it through.
All right, thanks, Mike. Okay, another one from Tim here. All right, so Tim is saying from the perspective of a landlord gives the tenant the 15-day notice for non-payment, but get nothing back, no communication. I would evict based on the failure to cooperate. Oh, sorry, more of a statement than a question. He's asking, I think, about, we think you're ineligible for rental assistance, and they give the 15-day notice and don't hear back.
So what I would say to that is what the the session law says is that if the tenant who owes rent and refuses to give their landlord the info needed to apply for the COVID-19 emergency rental assistance program, refusal is an act. Non-replying is not an act necessarily. And so how are you proving that someone has refused to assist without affirmative action? But at the same time, what else, the 15-day notice that's required under the session law has those very specific things that are required to be in there, the amount of rent that's due, the fact that the eviction moratorium is over and the rental assistance could be provided. But is there anything that says, were you even asking for proof that you've applied, for that the tenant has applied? Like, that's just, there's a whole bunch of the 15-day notice requirements under the session law don't even touch on that. So I would not suggest that non-communication is somehow a refusal to cooperate.
Yeah, I guess I'd add to that, right, that that you don't know at that point if the tenant didn't respond that they haven't applied, right? They may have applied and have a pending application at the point. You would, I guess, find out at some point as a landlord because you'd be communicated with. And eligibility is we put it in the chat, the link to the rent help amend page that talks about eligibility. People who fit those criteria on the rent help amend page about eligibility are eligible, and so it doesn't really, like you said, doesn't matter if they didn't respond. Next question from Tim for Mike is, does Homeline encourage litigation?
So I'm not exactly sure what Tim's asking. By the way, Tim is an attorney that works on behalf of landlords. He does some other work, I think, but he also represents landlords. I'm not sure if he represents any tenants. So does Homeline encourage litigation? Well, I can talk about what the tenant hotline does, since I run our tenant hotline. What I think we do at our tenant hotline is we try to offer people alternatives, and as much as possible, what the likeliest outcomes might be to those alternatives. Sometimes we talk about litigation as an option. We're lawyers, we're dealing in landlord-tenant law, which means that if there's a dispute, that it's ultimately going to get settled by a court, and we try to talk about the process, which is tremendously intimidating for most renters who many times are going to be going into court on their own. And so they want to know what they're going to be up against, what the process will look like, how to maximize their chances if they do go to court. If we are encouraging litigation, we're doing a pretty bad job of it. Relatively speaking, there's somewhere between 15 and 20,000 evictions filed every year by landlords. Those are never filed by tenants. I'm not sure how many rent escrows or security deposit cases combined, or ETRAs or lockouts. If you added them all up, I don't know if it's 1,000. I doubt it is throughout the state. So it's not something that we actively say, hey, let's help people go to court. That's not really what we're designed to do. We're designed to tell tenants what their rights and responsibilities are and what their options are. And some of those options do include litigation. And we walk through that with each and every client that calls us or emails us. If they're asking about litigation, which they frequently do, I want to sue my landlord, how do I do it? Will be kind of the opening question that we'll get some of the time. Just like a landlord attorney would get a question. I want to sue my tenant, how do I do it? And a good landlord attorney is going to talk through the possibilities with their client and say, here are the choices you have, here are the potential likelihoods based on the information that we have right here, which is what we try to do as well. So encouraging litigation, I don't think that I would ever use that kind of blanket statement about us. We talk about litigation frequently because that's where legal disputes end up, is in courts if it can't be resolved by the parties. But most of the disputes between landlords and tenants are resolved without court. As mentioned, 15 to 20,000 evictions each year. There's 700,000 rental units in Minnesota. Most landlords and tenants get along without court. And one of the things that we will do sometimes is we will talk tenants out of court. Hey, if you go to court, that's a case that doesn't really have much of a chance of success. I wouldn't do that if I were in your situation. Would be something we might say if somebody really doesn't have much of a case. But tenants are trying to figure out what their options are when they contact us. And that's what we try to help let them know.
All right, we've got 11 minutes and 2 questions. So you can take your time answering these ones if you want. Or if there's other folks that have questions that want to submit them, please do. But of course, if you don't right now and you think of something over the next week, we will, of course, be having another session next Wednesday at 1:30. And I'll put the link in the chat about where you can register. Again, next week is just going to be another kind of focused seminar on the phase out and what's going on with it. And we'll have plenty of time for Q&A. The following week, we'll have the housing court referee hoteling on, and then Dan Hilton from Housing Link the following week about rental housing trends. And then as we get into October, we'll be talking a lot more, as we did today, kind of about the October 12th date and the changes then. But in the meantime, we'll tackle these 2 questions. Lauren asked, circling back to the previous question that she had, Rachel and Eric mentioned forward rent protection and treasury guidelines if a landlord already received back rent. I'm concerned that my current tenant, who I already collected my 15-month back rent from zero balance, will continue to miss monthly rent going forward.
Okay, I think I'm on this one. So at least for like Rent Help MN and the as far as I'm aware, Zero Balance Project and the Ramsey County projects don't have any cap on how much a person can use, but it is the amount of time, so 15 months back rent. And then if my understanding is that, and Eric, help me if I got that wrong, but the phase 2 of the money that's going to be going through from Rent Help MN adds on a couple more months of eligibility. So I believe it's 3 more months, so up to 18 months all told, once phase 2 funds start kicking in, which I would assume the Zero Balance Project would probably have something similar, but that's an assumption on my part. I don't know that for certain. But essentially then, if you've used up all of your options, if you've used up all of your money, months and things like that, then that is a ineligible, you're no longer eligible for the programs unless something else comes along. But that would be, I think, one of the times when you would be fairly straightforward that someone is no longer eligible for these funds because they've used up all of what's allotted for them.
Yeah, you're right. I think the combination of the ERA 1 and 2 then allows up to 18 months. So, okay. Next question from Tim again. How long should it take for court administration to issue a writ? What if the sheriff refuses to enforce the writ?
So the second question, what if the sheriff refuses to enforce the writ? I'm not sure what happens with that. I've not heard of that before, not in this state. I don't know. I imagine the sheriff has to answer to somebody. Maybe it's just voters. I'm not sure who else they answer to, because I think that's an elected position. And so I'm not sure if they have a boss. I don't know. I honestly don't know the answer to the question. What if the sheriff refuses to enforce, how that can be compelled? Maybe it can be. I've just never had to answer that question. So I'm not sure if Tim has run into that issue in a case that he's worked on. How long should it take for court administration to issue a writ? Again, not a question that really was asked prior to the pandemic. I'm not sure if he's running into cases where the court is dragging their feet on issuing a writ once the judge has ordered it. But once the judge orders something, the court administration should be carrying it out, depending on how the judge's order is written. So it's hard for me to know exactly what issue we're trying to solve without knowing what's on the ground on that question. So, sorry.
You are right. I believe sheriff is a elected position. So
I didn't think I'd be answering that question today. Is a sheriff an elected position or not? But I think that's right.
okay. Tim just messaged 3 weeks for a writ and no enforcement.
Yeah, I'm not exactly sure what you do with that, Tim, or who you complain to. Maybe the county attorney would be a place to start, as maybe they answer to the sheriff on some level, although the sheriff's office has different roles. This is, I think, the civil enforcement division side for sheriffs. It depends which county it's in, things like that. Yeah. Ultimately, if it's 3 weeks for a writ, maybe it's a complaint to the chief judge of the county, or even the Court of Appeals. It would be my reflex answer. Again, I haven't really thought about these questions before.
All right. Thank you. Somebody sends a message that we're appreciated. Our webinars are appreciated. Thank you very much. I'm just going back to the chat to see if I missed stuff. While we have 4 minutes here. We did get a message from somebody saying there's a space for the in the Rent Help MN portal online. There's a space for the tenant to click on to have a letter sent to the landlord to show that they've applied. Someone else saying they had three case managers with Rent Help MN since May. Many pending applications since July. So thanks for sending in your comments and chat in the chat as well. So I think if there's no other questions, then we can wrap up. Thank you, Mike and Rachel, for fielding all these questions. Let's see, we probably had like close to 30 or so that's good. So again, folks, you can join us next week if you have more questions. I put in the chat the links to the rest of the resources on our website. And as always, renters, if you have a question, please call our hotline. But thank you for joining us today. We will have a recording of today's webinar up on our website in the near future, if you want to share with colleagues or want to rewatch anything. So thanks everybody, and have a good rest of your Wednesday.
Thanks, Al.
Bye-bye.